You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle, who is still not wearing a jacket. Bill, is that the new MO, or are we, going to see you in a jacket at some point in the future? What's going on here?
When it cools off, and maybe in the next week.
Right on. Anyway, go check out Bill's daily bankruptcy column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. Really interesting stuff going on this week. Bill, we're going to start off by taking a look at Detroit's municipal bankruptcy. It's obvious that Detroit is bankrupt. It's the largest and sickest municipality ever to file for a Chapter 9 bankruptcy in the United States. But a union, nonetheless, is challenging the city's right to be in bankruptcy. What's the theory for throwing this case out of court?
Well, pretty simple. The American Federation of State, County, and Municipal Employees contends flat-footedly that the municipal bankruptcy laws in Chapter 9 of the Bankruptcy Code are, get this, Lee, unconstitutional.
So by flat-footed, I guess this isn't going anywhere in your view.
Well, who knows? One could say that their theory is either extremely creative or, on the other hand, crazy. It is not entirely crazy because, guess what? In 1936, the U.S. Supreme Court, in fact, invalidated municipal bankruptcy laws as being unconstitutional. Unfortunately for AFSCME, Congress modified the law, and 2 years later, 1938, the Supreme Court upheld the constitutionality of municipal bankruptcy.
So we've all gone over this before.
Well, not exactly. And what I admire in their pleading is in pointing out that over the last 20 years, some members of the Supreme Court have developed the notion of federalism, where the court, to the thinking of some, is giving more power to the states. And so, therefore, AFSCME says that under this evolving theory of federalism, Chapter 9 is no longer constitutional. The problem with their theory, even if it is correct, is, I suspect, that no court is going to have the temerity to say that the statute is unconstitutional, because essentially only the Supreme Court has the ability to overrule its own precedents. So this is an issue, I think, that will not have a favorable answer for them unless they can manage to get it to go all the way to Washington. But they don't stop there. AFSCME also contends that Chapter 9 is futile because the Michigan State Constitution precludes messing with employee pensions. Now, on closer examination, maybe that doesn't hold water. The state Michigan Constitution says that pensions for municipal workers have the status of contracts. Now, states cannot impair contracts, but guess what?
Bankruptcy judges can.
Right. Under the federal Constitution, bankruptcy courts and federal authorities can impair contracts. So I am not sure how far that theory is going to get them. In any event, it'll be an interesting fight to watch. And by the way, AFSCME is the only entity of substance that is opposing Detroit's right to be in Chapter 9.
And last week, of course, we reported that the lawsuit that the Department of Justice filed seeks to bar a merger between American Airlines and U.S. Airways. Bill, in view of this suit, how long will it be before American Airlines can emerge from bankruptcy, either as a standalone or a merged entity with U.S. Air?
Well, I guess you could say don't hold your breath. The reason is, it doesn't look to me like there's going to be a settlement because American and U.S. Air say they're going to fight it tooth and nail till the last body drops. And the Govies have not shown any inclination to settle either. Frankly, settlement would be pretty darn difficult because you would have to lop off so many routes and things of that sort that you'd have to bring the other airlines in the country into the program to slice up what they have to get rid of. So that doesn't really strike me as being terribly feasible in the short run. Meanwhile, American is doing something that I thought they might but figured they wouldn't. That is to say, they went ahead and held the entire confirmation hearing last week, told the bankruptcy judge that he should nonetheless sign a confirmation order allowing them to emerge from Chapter 11 and put the merger in place when and if they beat back the Department of Justice antitrust lawsuit. This is a difficult question for the judge, and he asked for them to submit briefs telling him whether or not in these circumstances he should, shall we say, conditionally confirm the Chapter 11 plan. This, I think, raises a question for bankruptcy lawyers known as feasibility. Because as we sit here right now, if they were to try to implement a merger, even though it's not technically enjoined as we sit here this minute, you can be darn certain that the Justice Department would go to court asking for a temporary injunction. And the fact of the matter is, in antitrust in cases like this, the government almost always gets temporary injunctions. So if they try to implement the plan, they won't be able to. All things considered, there is a great question here of feasibility. And I'm going to be very interested to see how the judge rules. In fact, maybe he won't rule. Maybe he'll just sit on it for a while to see how that lawsuit in D.C. on antitrust progresses.
And Bill, we have some new numbers on the state of the bankruptcy economy. Is it good news or bad news for bankruptcy pros out there?
Well, I think it was maybe last week, Lee. Didn't you and I say it can't get any worse?
Yeah.
Well,
got this one wrong.
Yeah, I think it did. I mean,
we're not batting 1,000.
At least fractionally.
Yeah.
The latest numbers on liquidity stress on junk-rated companies is showing that liquidity is, if anything, getting a little bit better. The Moody's Liquidity Stress Index came in at 2.8% at the end of July. That compares to an all-time average of 7.2%. Now that means that right now only 2.8% of junk-rated companies have stressed liquidity, the lowest ranges of liquidity. And Lee, 2.8% ain't very much. Also, the rating agencies were expecting that the default rate would rise later this year in early 2014 to the range of 3% or above, but guess what? They've pulled back on that now. Moody's is currently projecting that the default rate for junk companies is going to remain at about 2.8%, but here's the bad part, Lee. They are projecting that the default rate, which is practically zero already, is going to drop further to 2.4% by the middle of 2014. And by the way, folks, the historical average on default junk is about 4.5%. In round numbers, that means we have about half the number of junk defaults right now than the historical average, and just a tiny fraction of what it was during the height of the financial crisis.
Easy money for issuers, I gather.
Right.
All right, finally, let's touch on the advance sheets. Bill, the most interesting case that you reported on the last week came to us from the 11th Circuit Court of Appeals in Atlanta. I gather the court broke new ground on what is or is not considered property of the estate. Fill us in on the details.
An extremely important decision written by a fine, extremely well regarded federal circuit judge by the name of Gerald Choflat. And by the way, Judge Choflat is the longest serving active circuit judge in the United States. The case is, I guess, a typical example of how hard cases make bad law. It arises out of the Chapter 11 of a bank holding company. In almost all of these bankruptcies, there will be a whopping and sometimes huge tax refund. Because, when a bank goes bust, you write down a whole lot of assets, there are huge losses, and therefore a big refund. The tax sharing agreements, however, among these families of companies always provide that the holding company files the tax return, and guess what? The holding company gets the tax refund, which could be sometimes tens of millions of dollars. The FDIC, as receiver for the failed banks, has been contending so far, unsuccessfully until this opinion, that the banks should get the tax refunds because they're the ones who paid the taxes in the first place and incurred the losses, therefore they ought to get the refunds. But until now, the courts had been uniformly holding that no, the tax refund goes to the holding company. The bank or the FDIC only has an unsecured claim for its share of the tax refund. Now that was all until Judge Choflat came into the scene, and he developed a theory that when the tax refund was received by the holding company, it is as though it were held in escrow. That, Lee, is the new holding of this case. There is a lot of law on the question of when assets are or are not property of a bankrupt estate. One of the most frequently used theory is one that the property is held in constructive trust. If I were to criticize Judge Choflat's decision, it would be because he did not pigeonhole his decision under existing law, taking property outside of the estate. Rather, he developed his own new theory that it is as though the property were held in escrow. This, I think, could cause a good deal of consternation among litigants in the 11th Circuit, which includes states like Florida, for instance, because it really, I think, opens the door to trying to take property out of a bankrupt estate. It is my fond hope that somebody in this case is going to make a motion for rehearing by all of the judges on the 11th Circuit. Now, it may well be that this result is perfectly correct, and I'm not suggesting that it's wrong, but I think it would be a good idea to have rehearing and see if they can fit this result into some of the existing notions of what is or is not property of the bankrupt estate. But in any event, if you're in the 11th Circuit trying to claw money away from a bankrupt company, go read this decision. It's called, as I said, Zucker versus FDIC.
All right, good stuff. Bill, thanks for that. That's Bloomberg News Bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching.